Okay, serious warning here, because I don't want you punching your computer screen through when I tell you about this. Because this is partly a follow-up to my single justice procedure video, but also want to comment on a couple of cases that you may have heard about. And when you do hear about them, I suspect you might be a little bit angry. So the first case involves a lady with Down syndrome. As a result of that, all her finances were controlled by the local authority. But the TV licensing people turned up on her doorstep, and it transpired that the local authority had either cancelled the direct debit or forgotten to renew it. So as a result, she was prosecuted. Um, but the local authority entered a guilty plea on her behalf, and she was subsequently fined. The second case involves a 90-year-old gentleman. Now, his car had run out of MOT and he hadn't sowned it. He hadn't actually driven in over a year because he was caring for his wife who had dementia. But he too was prosecuted and subsequently fined. Both these cases were dealt with under the single justice procedure. Um, Now, one thing I am curious about, and I haven't been able to get a definitive answer, is how the local authority were able to enter a guilty plea on that lady's behalf. I mean, I've been asking my friends who do court protection work, and nobody seems quite clear as to whether that's even possible. When people don't have capacity, as we say, and the argument would be, well, if this is somebody who's been deemed not to have capacity, and that's why the local authority had dealing with her finances, you can have what they call fitness to plead hearings. Now that's different from whether you understood the nature of the crime. It doesn't go to whether you committed the offence. It's just, are you in a position that you can understand the proceedings and give proper instructions? There is a procedure for that in the Crown Court, but in the Magistrates Court, which of course the single justice procedure uses, the justice being a magistrate, that only applies where it's an offence where imprisonment is a possibility. Um, because no TV license is what we call a strict liability offence. There's no mental element to it. There's no mens rea. You don't have to intend not to have a TV license or be reckless. If you don't have a television license, you commit the offence, and that is why it's believed that you don't need to have this issue as to whether or not somebody understands the nature of the proceedings. Now, you may be thinking, why on earth did the prosecution and indeed the court think these were cases that it was in the public interest to prosecute? And this shows another problem with the single justice procedure and the way it works. Um, Letters had been put in, from on behalf of the lady, and the gentleman wrote a letter explaining his circumstances. But because these cases are just dealt with by a sort of single prosecutor on what we call the common platform, which is a sort of digital document file, a lot of the time the prosecutor doesn't get to see these mitigation letters. So they just basically have something saying we attended a house and somebody didn't have a television license, or we ran a DVLA check and somebody had a car without an MOT that hadn't been sowned. I mean, it may well be that had that information been available and applying the test, realistic prospect of conviction, obviously that's, Lim probably would be passed, but in the public interest to prosecute, it may well be that a prosecutor who had access to all the facts wouldn't have chosen to proceed with these matters, or at least alerted the justice. Now, as I've mentioned, there is a procedure where if you are convicted under the single justice procedure and you didn't know about it, then you can apply to have that set aside. But in this case, there are two guilty pleas. So any sort of appeal is going to be very, very difficult. But this highlights a big problem with the system, and arguably it's going to get even worse. And let me explain why. The current system is that you have a single justice, one lay magistrate, and they are advised by the legal advisor, what we used to call court clerks. However, there is a pilot scheme in place now where it's called the 3-to-1 scheme, where there is one legal advisor for 3 magistrates. So they will sit 3 magistrates down in a room, but now the legal advisor isn't actually present. The legal advisor is available by telephone. So it's only if the magistrates need advice, they have to call them. And they're all sharing this one legal advisor. So there's not anybody sat there looking over their shoulder or just somebody they can just chat to about cases. It's probably fair to say that the magistrates themselves have expressed a lot of disquiet about this scheme. Now, one complaint is, well, hang on, if the legal advisor doesn't need to be physically present, why do we have to travel to the court to do this? Can't we work from home? The reason given is that, well, no, there are sort of data protection and security issues. Although the magistrates have pointed out that if the police apply for warrants, for instance, in the cases of very serious crime, because, to get a search warrant, you have to apply to a justice of the peace. That can be done by telephone and with the magistrate working from home. So I can see there is some strength in the argument that, well, if that's okay, surely something as routine as this should be. But more importantly, the magistrates are just worried that they're not getting the adequate supervision and they're not having the assistance that they need. And some magistrates have expressed it in terms of, if we make a wrong decision, we're going to get pilloried for this. I mean, it wouldn't surprise me as more anger boils over from these cases that, people will be baying for blood. Now, to stick up for the magistrates involved, it may well be that they had no idea as to the background of either of these cases. Because like I say, this is this whole thing of bulk processing of cases. They just get a massive file. They look at the papers, and if on the sort of evidence before them, which will just be in the form of witness statements, they make a decision. Now, on the single justice procedure form, you can actually attach mitigation or explanations. And one thing I'd like to know is, did the local authority in that particular case, did they actually explain the situation? However, it does seem that with the 90-year-old gentleman, I've seen a copy of a letter he wrote, and I think anybody reading that would certainly pause, or perhaps say this should be remitted to a normal hearing in open court, so we can actually look at this in a little bit more depth. So yeah, I'll keep an eye on what happens with these cases. I mean, there are mechanisms to actually, appeal decisions like this, notwithstanding the guilty pleas. There are certain things called the slip rule. It would have to be done within 28 days, though, and I'm not exactly sure as to when this was done. I mean, that's another thing with the single justice procedure. The cases aren't listed on any particular day. The magistrate just gets a big pile of files and work through them at your own time. But I'll keep an eye on this because I think it does show, it throws a lot of light onto the system. So there you go. As always, hope you found that vaguely interesting, vaguely useful, although probably just found it wildly infuriating, because I know that was very much my reaction. And it's very much been the reaction of all the lawyers I know looking into this. I mean, it does, show some serious deficiencies in the system. But if this pilot scheme is adopted, and I can see it may well be, because legal advisors receive a salary, but magistrates just get expenses. And this is a way of effectively getting 3 for the price of 1 in terms of the expenditure. So I can see this scheme going nationwide. And I can see even more, and I'm going to call this a miscarriage of justice, because it clearly is. But like I say, I'll keep an eye on these cases and update you as more news becomes available. If you did find that vaguely anything, please consider clicking, liking, sharing, whatever. I'll probably have to do another video now on whether you can sue me for the damage you've probably done to your computer screen or any sort of crockery in the general vicinity.